Hi, I'm Jim Gibson of the University of Richmond School of Law, and I'm going to explain the most recent development and the background of the copyright case involving Led Zeppelin's iconic Stairway to Heaven. It's Celebration Day for Led Zeppelin. The long-standing litigation over the band's iconic Stairway to Heaven song is finally over. Like lots of Zepp songs, it took a while to get there, but the Supreme Court just declined to review the case, which means that Zeppelin's win at the Court of Appeals now stands. So what was the case about? Well, back in the late 60s, Led Zeppelin toured with a band called Spirit, and Spirit's guitarist Randy Craig Wolfe wrote this song called Taurus, which they performed on the tour. A couple years later, Stairway to Heaven comes out. 43 years later, Wolfe is dead, but his estate files a lawsuit against Page and Zeppelin, claiming at long last that, in fact, Stairway to Heaven is an illegal, infringing copy of Taurus. The claim wasn't that it was an exact copy, rather that there was a particular guitar sequence involving notes of a chromatic descending scale and certain arpeggiated notes, individually played notes, rather than taking the whole thing. So let's replicate just that part of the two songs. Here's Taurus. And here's Zepp. So you can hear the similarities, but is it enough to get Zepp in copyright trouble? Well, the jury found that even if Page had copied from the song, it wasn't enough to constitute infringement. No substantial similarity, to use the copyright term. On appeal, a three-judge panel actually said no and sent it back for a new trial. And at that point, the parties might wonder how many more times they'd have to argue these issues. But then the full appeals court decided to revisit that panel decision, and it affirmed the trial outcome. And with the recent Supreme Court decision not to get involved, that's the way the case ends. But was it the right outcome? It really comes down to how much borrowing is too much borrowing, and this is a critical issue for copyright because all artists borrow from their predecessors, and in turn, future artists will borrow from them. That's how the arts advance. If we find infringement whenever there is copying, we're not promoting creativity, we're obstructing it. Of course, there comes a point at which so much is borrowed that the new work isn't really new at all. It's just the old creativity repackaged, and that's when we cross the line into infringement. So Jimmy Page took someone's creativity and added his own spin to it. But Wolfe surely did the same thing when he wrote Taurus. He wasn't the first to use chromatic scales and arpeggios or even the particular patterns at issue in the case. Go online, find Davy Graham's version of Cry Me a River, and you'll hear similar sounds. Some musicians even claim that use of those particular patterns date all the way back to 1659 when a composer named Giovanni Battista Granata wrote a sonata that used those patterns. And that's fine. All this copying, that's how it's supposed to work. So hats off to the courts for getting this one right. The outcome might be a heartbreaker for poor Wolfe's estate, but it's the right result for copyright law.